What I'd say at the outset is, at the CFTC, we are prepared to carry out the mandate Congress has given us in the context of the assets that we can immediately appreciate are likely to be treated as commodities and that will be subject to our regulatory oversight and the regulatory regime we currently deploy. We're doing that already in the context of certain enforcement actions. We're doing that in the context of direct engagement with the community, inviting people in to talk about what our regulatory framework looks like, and hopefully continuing to support Congress as they ultimately craft legislation that would help us.
So there's this debate playing out right now. Are crypto assets, cryptocurrencies, commodities, are they securities? The SEC says, well, alleges Ether as a security, it alleges other things as securities. The CFTC says, well, no, these are all commodities for the most part. What's happening here? What's the view? How does this get resolved?
Well, in truth, the way our regulatory framework works is that we need Congress to step in and help. There's a gap in how the law governing securities and the law governing commodities works as we apply that to this innovative technology that is assets created using distributed digital ledger technology. And so something I'd share right away is there is a harmonization between those two statutes, and there is a path forward. And we've used that path before in the context of defining swaps, the over-the-counter derivatives that became part of our regulatory mandate in 2010 with the Dodd-Frank Act. The SEC and CFTC worked together in collaboration after Congress gave us that direction that we could and should collaborate to find a path forward. I'm hopeful we'll see that again.
Many of the crypto companies I've spoken to over the past few weeks, all of the big ones say, look, there's regulatory uncertainty in the US. We need clarity. We need to understand what we can and we can't do at the moment. When it comes to lawmakers themselves, there's a number of bills being floated around. The Stabe-now-Boozman bill puts the CFTC in charge. Others are looking towards the SEC. It appears to be a mess at this point. Do you think that going forward there needs to be crypto-specific laws in the US? What does that look like?
Well, I do think that we'll have to be really careful to have dynamic regulation that is not just responsive to the asset classes that we see in the market today, but that gives us the flexibility and capability to respond as entrepreneurs and innovators, coders and developers of software protocols continue to release more and more interesting sort of asset classes and products in financial markets. Under immediately existing laws, there is provision to understand how securities laws would apply to any digital assets that qualify as securities, and those the same in the context of commodities. However, I agree with you. It is imperative that Congress step up and make plain what their preference is in terms of how to deal with the spot market oversight. I think that's the singular space. If we went very narrow, specifically to your uncertainty point, that spot market oversight, that definitional piece, is very critical. And I think it's helpful for us if Congress assists us in giving us that guidance.
I think our audience would love to hear a little bit about a particular case the CFTC is involved in involving Binance that was brought very recently. Can you give us any kind of updates on this? Binance has argued for a long while they're not headquartered in the US, they're not subject necessarily to some of those US laws. How does the CFTC plan to pursue this case?
So, Arjun, let me point out really quickly that the fact that a company is not organized in the United States and may not, in fact, intend to trigger regulation in the United States doesn't mean that they are free from regulatory oversight. Our regulations make plain that where you involve U.S. persons, where you involve U.S. customers, where you trigger or potentially cause effects that impact the stability of U.S. financial markets, we have authority. And in fact, going back to the 2010 Dodd-Frank Act, very explicitly, there's a provision there that we're using for the very first time in the Binance litigation. And that provision is an anti-evasion principle. The anti-evasion principle works in a specific way. It prevents someone from orchestrating abroad, outside the United States, overseas, a business that is intended very much to impact U.S. customers, to attract or solicit U.S. investors, and to have what we would describe as causes and effects in the United States. So our reading of what we've seen in terms of the evidence suggests that that provision could be applicable in the context of Binance. And so as a result, our Division of Enforcement has in fact brought a case alleging the same.
And just a quick one, Kristin, how's the CFTC plan to pursue this case? Have you spoken to Binance? Are they looking to settle, or is this going to court?
So any ongoing litigation matter is one that is shrouded in sort of the most significant protections, in large part because any defendant is certainly innocent until evidence suggests otherwise, and there's a fixed firm conclusion of law. So I want to be really careful not to prejudge what will actually happen in the litigation. And I want to say that typically in the context of any litigation, we are always ready to have conversations, and typically even ahead of the litigation. We've been in continuing conversation with the business to describe what we understand as potentially problematic conduct and to give them an opportunity to explain that conduct and to help us find a path forward. As of the moment, we can conclude that there is not an immediate path forward. That doesn't mean there couldn't be one, and hopefully there will be one.